How the New York Convention works, as I mentioned already, it contains two pieces. One, the obligation to stay litigation, and the other, the obligation to enforce awards from other convention states. So the obligation to stay litigation in breach of the arbitration agreement exists unless one of these two grounds for resisting a stay exists. The dispute is not capable of settlement by arbitration. So for example, in many jurisdictions, it's not possible to settle by arbitration questions of inheritance or questions of insolvency. So if it's not capable of settlement by arbitration, that exception would apply. The other is where the arbitration agreement is void, inoperative, or incapable of being performed. So if the arbitration agreement is pathological, it contains provisions that just don't make sense and do not evidence a clear submission to arbitration, then the court may find that actually it's not a valid arbitration agreement and the proceedings default back to the local courts. And in that situation, it would be possible for the local court to resist a stay. With respect to enforcement of awards from other convention states, again, there are very limited grounds for resisting enforcement. There's a defect in the arbitration agreement, incapacity or invalidity. There are procedural fairness issues, not given proper notice of the arbitration or otherwise unable to present his case. This is a ground that is often attempted by respondents that have lost in arbitrations. In most arbitration-friendly jurisdictions, this question is construed quite narrowly. Unable to present his case doesn't mean unable to present everything. It simply means given a fair opportunity to present the case. But some jurisdictions that are not arbitration friendly, that are looking to find excuses to refuse enforcement, can seize upon this ground as a reason for refusing to enforce. Jurisdictional issues, if the subject matter was beyond the scope of the submission to arbitration, you can refuse enforcement. Most arbitration agreements, if drafted properly, are extremely broad and will cover all types of disputes arising out of or in connection with a contract or a dispute under a contract. But occasionally there are very narrow arbitration agreements included in contracts, either because of defective drafting or the parties were attempting to create a narrow situation and got it wrong. There was a recent example here in Australia where essentially the contract, which was about the growing chickens, it dealt with permitted arbitration only of monetary disputes arising under the contract. And the court interpreted that quite narrowly to not include a claim for general damages because that was not a monetary claim under the contract. It wasn't a claim for payment that arose through the contract. So you have to be careful, and you'll cover this in subsequent modules. You have to be careful that your arbitration agreement is crafted sufficiently that you don't run afoul of this jurisdictional issue question. Similarly, the procedure adopted was not in accordance with the parties' agreement. Generally, courts in arbitration-friendly jurisdictions take a very narrow view of this exception. Disputes not capable of settlement by arbitration, that's the same as up above in grounds for resisting a stay, and enforcement would be contrary to public policy. This is one where in any arbitration-friendly jurisdiction that is viewed quite narrowly, but there are a few jurisdictions out there that take a more expansive approach to what constitutes public policy, and that's just something of which to be aware.